Hello, everybody. Thank you so much for joining us today for our third Tuesday webinar. We'll be talking today about updates to the COVID-19 related laws, including some major changes that were recently made to the Paycheck Protection Program and a couple of more things there. One thing I did want to bring up is that we are presenting today in a webcast format. I entered this in the chat, but what that means is there's not a phone number for you to call in to listen to the presentation today. You will need to use your computer's speaker system. So with that, I'm Janelle Stanton. I'm the Vice President of Communications here at MyHR Council. I know a lot of you have been on one of my or several of my presentations before. I was just looking at the list ahead of the presentation and I see a lot of familiar names. But I also do see a bunch of new names as well, which is always exciting. Just so you guys know, this is something that we do every third Tuesday of the month. We did take a couple of months off during the craziness that was the onset of COVID-19 and sort of the onslaught of new laws that came out related to that. So we took a couple of months off, but we're back doing our third Tuesday webinar. It's the third Tuesday of every month at 11 o'clock a.m. Central Time. So hopefully you guys can join us each month. So a couple of housekeeping matters. First of all, we are going to be recording this presentation. So everybody in attendance today will be able to get a link to the recording sent to them in an email after the presentation today. We also will be sending you the slide deck, so you'll be able to see all of the slides that were presented on today. And then we will send out also the HRCI credit code. So for those of you that are looking for HRCI recertification credit, you do have to be in attendance for the duration of the presentation today. But if you are, then you will receive that HRCI credit code for 1 hour of recertification credit. And then depending on the number of questions that we get today, I typically do send out a typed up Q&A to all of those who attended. I briefly paused that for COVID-19 related webinars because I was getting hundreds of questions that was hard to keep up with. So I'm going to try to do a typed up Q&A for any questions that come in today. I will do my best. So if you do have a question, please go ahead and put that in the questions box on the webinar widget there. And then last, before we jump into the content here, we are going to send out a brief survey. I talk about this every month. And, you know, as most surveys, I'm guilty of this myself. I don't always take the surveys either, but it does help us be able to know what topics you want us to present on. So this is how we've come up with the topics for today. So if you can please fill out that survey, please let us know what topics you would find interesting. I do see a question in the question box. Is there a dial-in number? So no, there is not a dial-in number. This is a webcast, so it is something you do need to listen to with your computer audio. So today we're going to be talking about the PPP as if we didn't have enough acronyms to worry about in employment law anyway. We've had, of course, the PPP. Now we have the PPP and I'll dive into all of the specific changes there. We also got some updates from the EEOC, specifically as it relates to accommodating specific employees. And then this is not related to COVID-19, but it's a new Supreme Court case that just was handed down yesterday. It's super important that all employers be aware of what that means and what you need to do now to be in compliance with that new case. So, all right, so I'm going to get jumped in here. So changes to the PPP. So after many employers, specific companies, trade groups, business associations, chambers of commerce complained Congress finally enacted the Paycheck Protection Program Flexibility Act. And so what this is meant to do is sort of help take out some of the confusion and some of the ways that the program was not very helpful to employers, especially if employers had to lay off employees due to government shutdowns or other business slowdowns. So after getting lots of complaints, and of course we know PPP was part of the CARES Act. The CARES Act is a very long piece of legislation that was passed hastily in response to COVID-19. So obviously there were going to be some issues with a big piece of legislation like that that's passed so quickly. And so the PPP SA is meant to address some of those issues. So this is just an overview here. I'm going to jump into each one of them. The covered period is now 24 weeks. No new loans after June 30th. There's a new minimum loan maturity, 2 new safe harbors, changes to the payroll expense threshold, and payroll tax deferrals. So I'm going to jump in here first and talk about the extended covered period. So the PPP SA expands the covered period, which is the period during which a borrower may use funds for potentially forgivable expenses, from 8 weeks to 24 weeks. So those of you that did receive PPP funds, you know that originally you only had 8 weeks from the date that those funds hit your account to spend that money. So you had to take those 8 weeks and get all of those funds spent, 75% towards payroll expenses and 25% towards allowed non-payroll expenses. So now we've got 24 weeks essentially to spend those funds instead. If you are a borrower, and for those of you that have been on any of my presentations before, you know I struggle with the word borrower all the time. So I don't know how to say it. I'm working on it, but so this is painful for me, just as I'm sure it is painful for you to hear me say that word. But borrowers that received a loan before June 5th can elect to keep their covered period at 8 weeks. Or if it's more beneficial for you, you can choose to now go with the 24-week increased covered period. So either way is okay if you did get those funds before June 5th. Now it does depend. So if you did receive those loans and have spent the proceeds based on an 8-week covered period, you might be better served by making this election and accelerating the forgiveness process. But, you know, you should consult with either your loan processor, maybe somebody in your finance department, if you're considering making that change. And now we are awaiting the SBA, the Small Business Administration, to give us confirmation that the expansion of the covered period will increase the maximum amount of cash compensation that can be paid to an employee. So if we look at now, you know, for example, if you pay an employee that, you know, they have a salary of $100,000 and you prorate that for 8 weeks, the employee is only able to receive $15,385 as an example. But if you prorate that same amount for 24 weeks, obviously they'll be able to get compensation up to $46,154. So we're still waiting to see if that length of time is going to increase the maximum amount of compensation that employee can receive. But hopefully the SBA will come out with some guidance for us on that soon. I did check yesterday to see if they had released any new guidance, and I hadn't found any. Okay, so another big thing here that was clarified. So it was not clarified actually through the text of the PPP SA, but there was a letter included in the congressional record that clarified the changes made by the PPP SA were not intended to extend the deadline to apply for a PPP loan beyond June 30th, 2020. So if you were thinking about applying, and there is still funds available in the PPP program, I know after initial reports were coming out about fraud and investigations. People, I think, got very gun shy, worried about applying for one of these types of loans. Totally understand that. But if you are still on the fence, they are not going to make any new loans under this program after June 30th, 2020. So please do keep that deadline in mind. All right, the next thing that the PPPFA changes is the minimum loan maturity. So for those that may not know this, maturity date is the date that refers to the termination date or due date on which an installment loan must be paid back in full. So the maturity date is the date the loan technically matures. The PPPFA establishes a minimum maturity of 5 years rather than the 2 years that had been implemented by the SBA for PPP loans made after June 5th. So regarding loans that were made prior to June 5th, 2020, so if you've already received your PPP funds before June 5th, the PPPFA does allow lenders and borrowers to mutually agree to extend the loan term to 5 years. So there's some good news there, but again, you need to go back to your lender if you got funds before June 5th to work out an agreement to extend that term. Under the PPPFA, lenders are required to provide complete payment deferral relief for borrowers, including payment of principal, interest, and fees until the date on which the amount of forgiveness is remitted to the lender. So the date that you're actually making that forgiveness request, you are required to have payment deferral up until that point. So the CARES Act had required deferment for at least 6 months, but not more than 1 year. So this is giving a little bit more time for that payment deferment relief. And then last, if a borrower applies for forgiveness within 10 months after the last day of the covered period and receives forgiveness, that borrower does not need to make any payment of principal, interest, or fees on the forgiven portion of the covered loan. So you've got 10 months after the covered period expires, so whether that's your 8-week period or the 24-week period, you've got 10 months after the date of the covered period ends to apply for forgiveness on that loan. If you receive those funds and you failed to apply for forgiveness within the 10 months after the last day of the covered period, payments are still going to be deferred until 10 months after the last day of the covered period. So you would still get that deferment period even if you miss that 10-month forgiveness application window. So just note your date that your covered period ends and that you've got 10 months essentially to get started on that forgiveness process. And again, we've talked about forgiveness different times in presentations that we've done. That is all taken care of through your lender. So whatever their process is for you to be applying for that loan forgiveness, that all is going to go through your lender. All right. So another couple of things that are meant to help employers with obviously the inability to rehire and business slowdowns are a couple of new safe harbors. There was already this rehire date safe harbor, but it's been extended to December 31st, 2020. So as we all know, part of the CARES Act and the purpose of the PPP was to incentivize employers to keep staffing levels the same. So the point was, let's not lay off people, let's not flood the unemployment system, let's keep people employed. But in reality, a lot of companies took out these funds and could not operate their businesses. For example, restaurants. So if you got PPP funds, but you couldn't operate your restaurant with the exception of carryout, well, you don't need a hosting staff. You don't need a wait staff, more than maybe one person available. And so you were essentially then looking at paying people just to be staying home rather than them getting unemployment. And so it didn't make a lot of sense. And so one of the things that this new PPP Safe Harbor does is it exempts certain borrowers from that loan forgiveness reduction when both of these conditions are met. So if the borrower reduced its full-time equivalent employee levels during the period from February 15th, 2020 through April 26th, 2020, but restores those levels by not later than December 31st, 2020, then you are going to be able to qualify for maximum forgiveness of that PPP. So it basically is giving borrowers until the end of 2020 to restore employment levels to those that are necessary to ensure maximum forgiveness. So that is a nice extension because obviously we don't know how long COVID is going to be going on, and even though we have states opening back up for business, there's still some very serious limitations on that. So let's see. I'm just looking at whether I had any questions here. Okay, so this is actually a great question. So somebody asked if the covered period is it 8 weeks or 24 weeks, or can you do it in between, for example, 12 weeks? That's a fabulous question and one I don't know the answer to. I don't know if we have any guidance on how that would work. I would assume that if you have up to either 8 weeks or 24 weeks to spend those funds. But if you obviously are an employer who got a specific amount of money, you need to still spend a specific percentage of those funds on payroll or non-payroll costs. So if you run out of funds in 12 weeks or 13 weeks, but can't stretch them 24, I would assume that your covered period would be when you run out of those funds. They're just extending and giving you the option and ability to pay out and use those PPP funds up to 24 weeks in duration. So I would assume that 12 weeks is just fine. I will get confirmation of that, and I will send the confirmation of my answer in writing to everybody that attends. So thank you for that question. All right, so this is the Rehire Safe Harbor. The other safe harbor that exists, and this one is new with the PPP FA. So this new safe harbor allows borrowers to avoid the forgiveness reduction due to a reduction in full-time equivalent employees if the borrower can document that either one, they had an inability to rehire individuals who were employees of the recipient on February 15, 2020, and they don't have the ability to hire similarly qualified individuals for those unfilled positions on or before December 31st. Okay, what the heck does that mean? So what that means is if you had an employee working for you on February 15th, 2020, that either was laid off or quit and you can't rehire them, and now you have been unable to hire someone that's similarly qualified before December 31st, 2020, that inability to hire somebody that was similarly qualified is not going to count against you for loan forgiveness, okay? The other option here that you can use as a safe harbor to say that even though you had a reduction in your employment levels, you still are qualified for loan forgiveness, is if you had an inability to return to the same level of business activity as you were before February 15th, 2020. You can tell this is the big cutoff date is February 15th, 2020, due to compliance with requirements established or guidance issued by the Secretary of Health, the CDC, OSHA, from March 1st, 2020 through December 31st, 2020, because your business is not able to maintain the standards for sanitation, social distancing, or any other worker or customer safety requirement related to COVID-19. So again, if due to CDC, OSHA protocol regarding sanitation, distancing, and all of those other requirements, your business is not able to return to the same level of business activity by December 31st, 2020, again, the safe harbor is going to help you be able to qualify for maximum loan forgiveness of your PPP funds. They're basically going to say, we understand that it's very difficult to return to the same level of business activity given these heightened standards for sanitation and social distancing. So we don't want to punish you for having your employment levels dip because we understand. So again, another couple of safe harbors that employers might be able to use to justify reducing their employment levels and still having that PPP fund, that PPP funding. Hopefully here the SBA is supposed to come out and let us know what type of documentation is necessary to satisfy these exceptions. Obviously thinking through, certain types of businesses like theaters, live music venues, they may not be able to operate before the end of this year, and who knows how long into 2021 due to COVID-19 limitations. So we don't know yet what type of documentation is necessary to justify these exceptions, but what I've been advising my clients is, obviously, you don't know what might happen this fall. We don't know when a vaccine is going to be available, but I would just continue on a monthly basis documenting either your inability to rehire previously employed employees, or that you're unable to go back to the same level of business activity. Just keep documenting that. It just on a Word document, really anything typed out. There's no place that you need to go right now to apply for these exceptions or safe harbors. So just document so that you can keep track of that, so that when time does come to apply for one of these safe harbors, you've got that documentation to back you up. One of the questions that I received here is, what if the decision is made to reduce headcount in your business in the next few months due to customer demand? And again, I'll go back to that slide. So what the rehire date safe harbor says is that if you reduce your employee levels between February 15th, 2020 and ending April 26th, 2020, that is the layoff period in which you would be eligible to apply for this safe harbor. So we don't have any guidance at this point that layoffs that occur after April 26, 2020, but are restored by December 31st would qualify an individual for loan forgiveness. We don't have any specific information on that. If we do, I would be happy to share that with you. And I'm getting a lot of questions here, so I'm just going to keep going and I will peruse those more towards the end here. I know one of the biggest things that employers were excited about here was the new payroll expense thresholds that are part of PPP FA. All right, so previously, employers who receive PPP funds, and again, this isn't something that was part of the CARES Act. This is something that the SBA imposed, this requirement that at least 75% of loan proceeds be used for payroll expenses, and then those limited non-payroll costs, for example, for rent, were limited to only 25%. So in order to maximize your loan forgiveness, you had to meet those 25% loan amounts. So these provisions essentially said that a borrower's loan forgiveness amount would be proportionately reduced to the extent that payroll costs did not meet that 75% threshold. So they had to spend 75% on payroll costs, or you would have a proportionate reduction in your loan forgiveness. So if you only spent 70%, then 5% of your loan forgiveness would be wiped away, essentially. And now the PPP FA has imposed a new statutory limit. So where the CARES Act didn't previously specify an amount, but the SBA did, this new act came in and set the statutory limit. So in order for a borrower to receive loan forgiveness, the borrower shall use at least 60% of the covered loan amount for payroll costs. And then obviously the remaining 40%, not $40, 40%, sorry about the typo there, are able to be used on limited non-payroll costs, again, things like rent and mortgage payments. What we are still waiting on SBA guidance on at this point is, so previously, under the old regime, if a borrower did not meet the 75% threshold, the borrower could still be eligible for partial forgiveness of the PPP loan. So like I said, if you only spent 70% on payroll expenses versus 75%, your partial forgiveness would be reduced by that 5% difference. Under the Flexibility Act, the PPP-SA, as it's technically written, it makes it seem that if the borrower does not meet the 60% payroll threshold, then no portion of the PPP loan may be forgiven. So rather than having it seems like now it's an all or nothing sort of cliff that if you don't meet that 60%, then none of it is forgiven. This does seem like not what Congress would have intended, and we do anticipate a technical fix to clarify that issue. But again, we are waiting on additional SBA guidance on that issue. Like I said, several senators have already come forward and said that that was not their intent. But the way it's currently drafted, it does make it seem like if you don't meet that 60% threshold, then no part of the loan may be forgiven. So again, that's something that you do need to stay tuned on. Okay, another change with the PPP FA is payroll tax deferrals. So previously, under the CARES Act provision, PPP borrowers were ineligible to defer payroll tax payments following the forgiveness of a PPP loan. So now this change ensures that borrowers can take full advantage of that deferral provision that was included in the CARES Act. So previously you couldn't have both. Now they've changed that, and so it eliminates that provision that made PPP borrowers ineligible to defer those payroll tax payments. All right, so switching gears a little bit here. Need a coffee drink there. So the EEOC, the Equal Employment Opportunity Commission, has updated their guidance for employers regarding a number of really, I would say, important and issues that maybe didn't come up very often for employers before, but are now coming up constantly. So I can tell you that as an attorney, previous to COVID-19 entering our, consciousness, we advise our clients on the ADA, on the one-off basis. Maybe a company would have 2, maybe 3 ADA questions in a particular year. Outside of PPP loans, we are advising the most on ADA-related issues right now. This has just absolutely exploded in importance, and so I'm going to give a little bit of background before I jump right into the guidance. But those of you that employ 15 employees or more are governed by the Americans with Disabilities Act. So 15 employees or more. Then there's state versions of the ADA as well. So Minnesota, for example, has the Minnesota Human Rights Act. That very closely tracks the ADA and applies to companies that have 1 or more employees. So every employer in Minnesota is going to be governed by the Minnesota Department of Human Rights Act, assuming they have 1 or more employees. So you need to know that you are governed by the Americans with Disabilities Act and likely a state version of the same, even if you are a very small employer. So a couple of things that the EEOC updated on their guidance here. So they clarified for us who is considered a higher risk employee. Now, this is, again, from the EEOC. This is not medical advice, but this is what the EEOC would consider to be a higher risk employee for contracting COVID-19. So clearly, individuals that are 65 years old or older, and individuals with underlying health conditions like the things that we've already been hearing about: chronic lung disease like COPD, asthma, serious heart conditions, severe obesity, liver disease, immunocompromised individuals. So many people with those underlying health conditions are going to be considered a higher risk employee. Now, one thing I want to mention about these two high-risk categories, there is no accommodation under the Americans with Disabilities Act specific for age. So employers are not required to accommodate an employee under the ADA because the employee is 65 years old or older. There might be other reasons to accommodate that particular employee, but age is not considered to be a disability. Maybe some of you might argue about that. I know, I think my parents probably would argue about whether age is considered a disability, but individuals with underlying health conditions, though, might need to be accommodated. So I'm going to jump into more specifics there, but again, this is just what the EEOC is saying is a higher risk employee. So another question that the EEOC has provided guidance on, and I'm happy that they did, because again, this is another question that we get from our clients all the time, is what does an employee need to do to request an accommodation? So in order to request an accommodation, either the employee themselves or a third party, like the employee's doctor or perhaps an employee's family member, may make a request for accommodation either verbally or in writing. So they can do it through conversation or they can do it in writing, requesting an accommodation for an employee's underlying health condition. So again, any of these that I listed here. It is important to note that the request, the employee's request or the third party's request, does not need to use the specific term reasonable accommodation or even reference the ADA. If an employee just says they have an underlying health condition and they maybe can't come into work for a while, or they need some other type of, assistance or protocol put in place for them, that the ADA is going to say that that's enough to mandate that the employer take action. So it's not just listening for reasonable accommodation or ADA. If it sounds like they're telling you they've got an underlying health condition that might need to be looked into, then it is incumbent on the employer to engage the employee in what's called the interactive process. I'm going to explain that a little bit more right now. So the interactive process under the ADA is just a really fancy term used to mean have a discussion with your employee about their medical issues and how you might be able to work with them to allow them to continue working for your company. So what I always recommend to my clients when you have an employee bring up an underlying health condition and the possibility for a reasonable accommodation, you right away give them an interactive process questionnaire. You send that to the employee along with a copy of their job description, and you have the employee's physician fill out that interactive process questionnaire to tell you exactly what type of disability the employee has and whether that disability can be accommodated, and if so, how. Now, there's a lot of times that I counsel a client on those interactive process questions where the doctor doesn't fill out the entire interactive process document. I know they're busy people, but you do need to push back and go back to the employee and say it's very important, and tell your doctor it's very important that this document get filled out completely, because you don't want to put your company in the position where you're making medical decisions on behalf of your employee. Leave that to the physician. Let the physician tell you whether the employee has a disability and whether it can be accommodated. Okay, so you do need to look and see, first of all, whether they have a disability and if a reasonable accommodation could be made to allow that employee to continue working. Now, there are some limits to this. So the ADA leave is not intended to be medical leave. And so I have looked at interactive process questionnaires for clients that have got there where their employees' physician said that they could not return to work until there was a vaccine for COVID-19. That's not a reasonable accommodation unless that we knew the vaccine was coming out in 2 weeks and it's here, but maybe it's going to take 2 weeks for the employee to be able to get it. Saying that an individual needs to be accommodated by no work until a vaccine for COVID-19 comes out is probably not going to be a reasonable accommodation. If the physician says that the employee needs to be able to work from home until there's a vaccine for COVID-19, and the employee is fine to work from home, they work well from home, and you have a really easily transferable, like it's very easy for your employees to be able to work from home anyway, then that is probably a more reasonable type of accommodation. However, as we all know, there are many, many employees that do not do good work working from home. They don't get assignments done on time. They're very difficult to reach. We wonder if they're watching movies or taking naps all day because we're not quite sure what they're doing. I'm speaking from a little bit of personal experience here, but so some people, if the doctor says the only accommodation is for the employee to work from home until there's a COVID-19 vaccine, and that employee is terrible at working from home, well, that might not need to be accommodated, because remember that the Americans with Disabilities Act only requires employers to accommodate a qualified individual with a disability. If the employee cannot sufficiently work from home, they cannot come into the office until a COVID-19 vaccine is found and readily available, then again, you might not be able to accommodate that employee. But you do need to look at all accommodation requests on a case-by-case basis. So you can't make one blanket accommodation for everybody. You do need to go through this process with anybody that tells you that they're too scared to come back to work. So it's not a one-size-fits-all solution here. Also, one other thing I want to point out about the ADA and the interactive process is there is an undue hardship exception in the Americans with Disabilities Act. So if providing an accommodation to an employee would cause your company an undue hardship, it is possible that you will be able to allege that undue hardship as a reason for denying the employee's requested accommodation. So if you're in an open floor plan and you have 6 employees come to you and they say they all need their own enclosed office, and the cost to build 6 enclosed office spaces is so cost prohibitive, it would cause your business functions to cease or your financial viability to be impacted. This is obviously a big example, but that could be potentially an undue hardship that an employer could assert to deny an accommodation that was requested by an employee. I will note that undue hardship burden is a high burden to meet, but some of the requests for accommodations that I'm seeing from our clients would very well fit that undue hardship exception. So I know this was a lot and a big sidebar on this particular slide, but like I said, I'm advising 20 times a day on ADA and accommodations and employees with underlying medical conditions. And you've got to get this right, because I see this as one of the big areas of litigation that is going to come out of COVID-19. Along with workers' compensation and some other things, the ADA is going to be crucial to get right here until we get a vaccine, and those employees that are higher risk are going to be safer to come back. These are going to be issues that aren't going to be going away quickly. All right, so again here, some more updated EEOC guidance that we got. So can an employer bar a higher risk employee from coming back to work? So, let's say you have an employee that is over the age of 65, or they have one of those severe illnesses that makes them a higher risk for COVID-19. Maybe they're a pregnant employee. And even though that concern for their safety and their health and their well-being might very well come from a well-meaning place in your heart, it is not appropriate for an employee to bar or exclude an employee. You can't exclude them or take any other adverse action. The ADA does not allow that to happen. So even if they're high risk, and let's say you have an employee that is, they have COPD or asthma, one of those severe lung diseases, and they've got asthma, they've missed tons of work because of it in the past, but now all of a sudden this asthmatic employee is wanting to come back to the office and work, but they're high risk. So you think, well, why don't you stay home and work from home? Or you tell them that they're not allowed to come back into the office until there's a vaccine or something like that. That would be a violation of the Americans with Disabilities Act that would cause you potentially litigation risk. The only exception to your ability to bar an employee from the workplace is a rare exception called a direct threat. So if the employee's condition poses a direct threat to his or her health that cannot be eliminated or reduced by reasonable accommodation. So employers need to be really careful about trying to use this exception. It does require a really thorough threat analysis, including individualized assessment based on the relevant factors like severity of the potential harm to the employee, what chances are there that the harm would occur, gauging the likelihood that a person will be exposed to COVID-19 in the workplace, and then figuring out whether that threat can be reduced or eliminated with one of those reasonable accommodations. So again, I point this out so that it is something that does exist out there. However, I have rarely been able to counsel an employer on a good time to use this direct threat exception to bar an employee from coming back to the office. So just know that there is that exception, but it's a really very difficult to reach. All right, so one thing, again, that I'm always advising employers on is under the ADA, their employees and employers are required to have this dialogue back and forth to figure out what is the best accommodation that will allow the employee to continue working. Now, the ADA does not require that the employer give the employee the accommodation of their choice. So if an employee, your interactive process questionnaire, you get that back from the employee's physician, and the employee's physician says that it's fine for them to go back to the office as long as they can, sit separately from other employees, and everybody else in the office is wearing masks, and you're taking 3 other types of protective measures for your employees. So let's say that's what the physician says, space them out, social distancing, hand washing, masks, and then they're fine to come back to the office. But then the employee tells you, well, I would actually feel more comfortable working from home. The physician has said that the employee is able to work as long as they're, spaced out separately from their coworkers. You're not necessarily required to then just allow the employee to work from home. So you're not required to give them the accommodation of their choice, just so you know that. But I would encourage employers to really think through all of the different possible accommodations that might exist for higher risk individuals. So, the EEOC gave some of these examples. So providing additional or enhanced protective gear beyond what the employer may generally provide to employees returning to its workplace. So, maybe for all of your employees, you're going to be giving them face covering, you have hand sanitizer stations set up, you've got signs to clean the copier after every time it's used, and you've got some distancing protocol in place. So it might be such a thing that you're required to provide additional protective gear. So maybe we've all seen them at this point at the bank or drive-thrus or at the grocery store, but maybe a plexiglass shield between that employee's workspace and the public. So maybe putting in some additional type of protective gear. That could be a reasonable accommodation. Additional or enhanced protective measures. So, again, just physically separating them further. Maybe you provide somebody with an office that has a door that wouldn't normally have an office, but because they are, required to be more physically separated, maybe putting them into an office or other space to give that separation makes sense. Another accommodation that the EEOC pointed out is temporary modification of work schedules. So maybe you need to add a third shift on so that there's fewer people working both the first and second shift. Nobody loves third shift. I'm aware of that. But you might need to think about adding another shift or, doing a furlough where everybody's working a partial week. So maybe you cut everybody's hours by 10%. So that there are fewer people working on the work site at once. So again, just modifying those work schedules to limit the number of people that are working in a particular space at one time. Physically relocating employees to another area of the workplace. I've kind of already talked about that. And I do understand that most employees want an office. I've heard in the past very interesting excuses for why an employee needs an accommodation to have an office as a ploy to get an office. I'm aware that that happens, but if it's something that the physician recommends and it's something you can provide, definitely I recommend, considering that. This brings up another good point about ADA accommodations that I hear a lot from employers. So let's say you do give an employee an office that wouldn't otherwise be entitled to it. There are probably other employees sitting in cubicles still that are going to look at that and be very upset and wonder why somebody else got an accommodation and they didn't. And your answer is always, we accommodate individuals who make the appropriate request. You don't tell them why you've made the accommodation. You don't say anything like that. You just ensure that they know that employees who make requests for accommodations, you consider those and you look at those, and that's all you really need to respond with. Of course, it is definitely still recommended that if employees can telework or work from home, that is going to be by and far your best defense against any type of claim that your employees might bring for, negligently contracting COVID-19. So one of the things I talked about already was the expansion of workers' compensation claims. And so employees who become ill with COVID-19, who are required to report to the workplace, are going to be, at least in the state of California so far, but it could expand, are going to be presumed to have contracted COVID-19 at the workplace such that they are entitled to make a workers' compensation claim. Well, if your employees can telework and they are teleworking, obviously, if they contract COVID-19, they have not contracted that at work, and you're going to be able to defeat that workers' compensation claim. Again, if it's something that your company can withstand, obviously if you're in manufacturing or you're in a services industry, telework is not an option for many of your employees. But if it is, I know it's not a best case scenario for a lot of people. I don't particularly like it, but it is a great solution, again, until it becomes much more safe for employees to be going back into an office environment. All right, so like I said, I did have one more slide here that is not related to COVID-19, but is a really, really important development as of yesterday. So before yesterday, and if any of you have taken any of our anti-discrimination courses with us in the past, you know about Title VII of the Civil Rights Act of 1964. So Title VII protects individuals on the basis of sex, race, national origin, but it did not specifically extend the definition of sex to either sexual orientation or gender identity. So Title VII just said sex. It did not extrapolate on what they meant by that. But yesterday, the Supreme Court held in kind of a surprise 6-3 opinion decision here that Title VII prohibitions on employment discrimination on the basis of protected class status does include discrimination on the basis of sexual orientation or gender identity. Many states had already taken that stance that the definition of sex includes pregnancy, disabilities caused by pregnancy, sexual orientation, and gender identity, but the vast majority of the states had not adopted that opinion. So now that the Supreme Court has ruled on it, it does make it the law of the land. So any companies or businesses that are required to comply with Title VII are going to now be governed by this new definition of sex. And so a couple of things that you need to be aware of as an employer. You should look at updating employee handbooks or your equal employment opportunity policies to make sure that you have the full definition of sex to include sexual orientation and gender identity in that policy. So just making sure that you update that. And just so you know, anybody that is a current client of ours, we will be emailing all of our current clients a new EEO policy to include in your employee handbook that will have this expanded definition of sex in it. So if you are a client of ours, you should look for that email to be coming to you shortly. But then the most important thing to do here is to train your management teams on sexual orientation and gender identity as protected classes, because you want to make sure that your frontline managers know, first of all, when to recognize sexual orientation or gender identity discrimination. So what forms might that look like? Your training should talk about, different types of gender identities, transgender, all of the different versions of gender identity differences about sexual orientation, so that in giving examples of what might be discrimination or harassment on the basis of those new protected classes, so that your management team will be trained and know when somebody's behavior, somebody's actions is going to rise to the level of discrimination on the basis of one of those protected classes, so that they know to report that to HR, so that it can be investigated, and again, so that the company avoids any litigation or lawsuits for failing to investigate and properly discipline discrimination or harassment on the basis of that new protected class. So I do anticipate putting out a training here in the next month or so that would be meant for management teams on sexual orientation and gender identity. So be watching for that if you're a client of ours. You will find that in our Solution Center here in about the next month. So that is a training, again, that I'm working on with my team to put together. So with that, that's all the information that I have for our presentation today. I did want to make sure that everybody does know that we have our myhrcouncil.com/COVID-19 page. On that page, we have a number of resources. So we have blogs that were written by our team of attorneys. We try to keep them as updated as possible. We have links to previous webinars that we've put on in the past regarding COVID-19. So there's a couple of additional webinars there. Do note that they're going to be now, so the content was relevant and accurate as of the date that we provided the webinar on. And so this is a fluid situation. You need to make sure you're looking at the dates on some of those items. But we've got some forms, FFCRA request forms. There's a number of policies there. So I would just have you, if you haven't checked this out yet, go ahead and look at our COVID-19 Employer Toolkit. It's got a lot of good information there. And for those of you that are not clients of ours, I'm also putting here our link to get subscribed. So it gets you access to our team of licensed attorneys to answer all of these legal questions you might have regarding COVID-19 and really any of the HR and employment law questions that you might have. So with that, I do have a little bit of time here. Let me just look at some of these questions and see if I can answer some more of these for you. Okay, here's a great question. So this is a question about accommodating an employee who doesn't have their own underlying health conditions, but a family member they live with does. Do you need to accommodate that? So great question. The answer is no. You are only required as an employer to provide an accommodation under the ADA to your employee. You are not required to accommodate your employee's family member's serious health condition. Now, one thing to keep in mind is if your employee's family member contracts COVID-19 and your employee needs to stay home and care for that family member, then they're going to be entitled to that FFCRA leave, that 2 weeks, up to 80 hours of paid leave under the FFCRA. Oh, here's another, this is an ask, and I will absolutely do this. So somebody had asked if I can make available a sample questionnaire for the interactive discussion for employees requesting accommodation. So yes, I will make a note for that, and I will put that interactive process questionnaire as well as our, we have a MyHR Council interactive process document that spells out the whole ADA process. So like I said, it sounds complicated. It's really a conversation, but I'll send that to everybody that's in attendance as well. All right, let me see what other questions we've got here. Yeah, so this is another question here. So we still have a lot of employees that will not return. They just will not return for one reason or another. They're too scared. They get great money on unemployment, at least through the end of July. So if you have made a written offer of employment to an employee to have them return, and the employee denies your offer, so either they say they're too scared to come back to work, or they say, you know, what if they want unemployment, you know, they're going to have issues qualifying for it after that. But if they won't return and you have it in writing that you've made the written offer, they've declined the written offer, that also does not impact your eligibility for loan forgiveness under the PPP. So make sure that you put in writing that offer to rehire the employee and that you have their declining that offer in writing. That will cover you again for PPP loan forgiveness purposes. And just so you know, if in many states, if an employee, if you make that offer and if you make that offer and you are, turning that down, that's going to impact your eligibility for unemployment. I don't understand this question. So here's a question. Will any other protected status included in current policies be okay until our new guidebooks are printed? So this is regarding the EEOC policy question. So with the EEOC policies, typically what we, have, we write in those policies is sort of a catch-all. So any other characteristic protected by federal, state, or local law. So yes, that would be sufficient for you to maintain that until you're able to update your handbook. That's perfectly fine as a catch-all. So just whenever you're going to update your handbook next, I would recommend getting that updated language about the updated definition of sex in there. So, all right, well, we're right up on the noon hour here. So I'm going to go ahead and end the presentation. Again, I'm going to take a look at the Q&A and see how much is here. If it's not too unruly, I will type that up. I did the question about the 12 weeks versus 8 or 24. I will absolutely follow up with that since I did talk about that during the presentation. So I'll try to get, again, that out to you. So those of you that have done our presentations before know that sometimes it takes some time for us to get all of these materials together. Please sit tight. You will receive the recording and the HRCI credit and all of the other resources I talked about today. You will get that email. It may not be today. It may not even be tomorrow. Thursday's probably the latest that it'll get out because I do need to wait for that recording to download, but you will receive the follow-up email. So just watch for that. But thank you so much, everybody, for attending today. I hope you found the content to be helpful. I'm putting our information here, so if you have questions, please let us know. Otherwise, have a great day and stay safe.